Hey, what's going on, y'all? So in a previous video, I shared a purchase and sale agreement with you, and I gave that agreement to you absolutely free. And if you haven't had a chance to check out that video, I highly recommend you watch that video first before going through this one. And you can watch that video in a link that just popped up on the screen above. All right, so in this video, what I'm gonna do is share with you the next part of the entire sequence in order to get your deals closed. All right, so now that you know from the previous video how to sign a regular purchase and sale agreement with a motivated seller, what I'm going to share with you today will allow you to make money on the other end with your cash buyers. And we're going to use what's called an assignment of agreement of sale. And I'm going to walk you through the entire agreement today, step by step. And somewhere in this video, I'm going to share with you how to get access to that agreement as well. So be sure to watch this video until the very end, because I'm not going to tell you exactly where it's going to pop up, but somewhere in this video, I'm going to share with you a link on how you can get access to the assignment of agreement of sale that I use in my business coming up. Hey everybody, it's Jamel Gibbs with the REI Education Academy, helping you close deals consistently in your real estate investing business. So on this video, what we're gonna do is walk you through an assignment of agreement of sale. And if you haven't checked out my recent training on what to look out for when you're filling out your assignment of agreement of sale, that video should be popping up right now on the screen. Be sure to check that video out. That video will give you some tips on what you can add to your assignment of agreement of sale in order to make it foolproof. And I'll also share some of those details with you on this video as well. So we're gonna hop over to my computer and we're gonna go through this agreement line by line. Now remember, watch this video until the very end, because somewhere in this video, I'm gonna share with you how you can get access to this document, and that way you can use it in your business as well. So let's go ahead over to my computer.
All right, guys. So as I've mentioned, what I want to do is show you how to use the assignment of contract, how to fill out this assignment of contract so that you can get paid in your real estate investing business. So as I've mentioned before, in a previous video, I've shown you how to fill out a purchase and sale agreement. So if you haven't checked out that video, again, as I've mentioned earlier on this particular video, be sure to watch that video before you watch this one. That way, you know how to get a contract filled out with a motivated seller. And on this end, you'll know how to get a contract filled out and get paid from a buyer on the other end. All right. So what we're going to do is go ahead and review this particular agreement. I just want to take you guys through the ropes, let you know what to look out for, how to fill out the contract, what to put where on this agreement, and ultimately let you take it from there so you can go out and get some checks in real estate. So as you can see, this is an assignment of contract, and it basically says this agreement is made between your company, and what you'll do is put your company here or your personal name if you're a sole proprietor, okay? And then it goes on to say hereafter known as the assignor and buyer, which will be your cash buyer or your end buyer's name here. Hereafter known as the assignee. Now, notice you're the assignor, your buyer is the assignee in this agreement. It says for property located at whatever the property address, you're going to enter here. Okay. Then the description, the same way, again, if you haven't checked out the purchase and sale agreement video training, be sure to check that out. And in that video, I show you how you can get the parcel number. So that parcel number is what you're going to put here. Okay. And then it goes on to say, whereas assignor entered into a real estate purchase contract with the seller name. So this is the person that you're buying the property from. So whoever you sign the agreement with on a purchase and sale agreement, their name is going to go here. And it says sellers for the subject property located at, again, entering the property address here. Okay. It says, whereas assignor wishes to assign its rights and interest in real estate purchase contract, it is hereby agreed between assignor, which is you, and assignee, which is your end buyer, your cash buyer, as follows. And then there's multiple points that we're going to cover real quick. It basically says, 1, the assignee shall pay assignor. So your buyer is going to pay you an assignment fee in the amount of whatever you guys negotiate. So if it's $10,000, if it's $20,000, if it's $5,000, whatever it is, you're going to enter that amount here. U.S. payable at closing of transaction between assignee and assignor. Number 2 says the escrow company for this transaction shall be whatever your title company or attorney you decide to use, and you're going to enter them here. And it says buyer must close on the transaction on or before the closing date. Now, one thing that I like to add here, I'd like to mention, what I'd like to do is make sure that the closing date is on or before my closing date with the seller. Preferably, I want to close a week or 2 before my contract is due. It depends on how much time we have, and that's something that you would have to negotiate with your buyer. But what I like to do is give myself a little bit of room. And I mentioned that in that other video when I talked about assignment of contracts. And again, that video is linked up at the top in the cards as well. But what I personally like to do is make sure that I give myself a little bit of breathing room so that if the buyer decides that they can't close this deal, I still have time to go ahead and sell the property and still be able to close it on time. Because if the attorney ran the title already and everything is already set in place for closing, finding a buyer is the only thing that I need to do in order to get it closed. We don't need to run title again. All of that stuff is already done. Okay. It says assignee shall deposit whatever you negotiate by 5 p.m. on whatever date with designated closing. Now let me go back to where it says EMD here. So you're basically going to enter the earnest money deposit. Now let's just say, for example, you put down $10 as an earnest money deposit with a motivated seller. What I personally like to do is collect a minimum of $1,000 from my buyer. Now, if I put down $500, then I'm going to collect a minimum of $1,000. Now, let's just say, for example, I put down $1,000 with the motivated seller, which is rare. Then what I'm looking to do at that point is collect double the amount that I put down. So if I put down $1,000, then I'm looking to collect $2,000 as an earnest money deposit. And what that does is it protects me. Okay. I know that I put $1,000 down, and if my buyer doesn't perform, worst case scenario, this is a non-refundable earnest money deposit. And if they waste my time, I get to keep that earnest money deposit. It's completely non-refundable. Non-refundable assignment fee, non-refundable earnest money deposit. All right. And then what you're going to do in order to make sure that they keep it moving and get you to earnest money deposit as quickly as possible, you want to make sure that you give them a deadline. Personally, I like to give 24 to 48 hours, but let's just say it's a Friday. I'll give them until Monday in order to get that done. But you don't want to push it out too far because then, each day that goes on is another day that this buyer can potentially not close this deal and waste more of your time. Okay. On the flip side of that, the buyer can close a deal a lot quicker and you can get paid as well. So these are just some things that you want to keep in mind in regards to the earnest money deposit, as well as the amount of time that you provide them in order to get the earnest money deposit over to your closing agent or your closing attorney. It says the assignee is aware that the assignor may accept backup assignments of contract up and until the deposit is placed with the title agent. So this is basically letting them know they got to keep it moving. They got to get it done. If they don't get the earnest money deposit in by the date that you set, again, usually 24 to 48 hours, based on the day of the week it is, then you're going to continue to accept offers. And, if someone else comes with a better offer, then they're just basically going to lose out on the deal. Number 5 basically says assignor has negotiated a purchase price on the subject property of whatever you negotiated on the purchase and sale agreement with the motivated seller. That price is going to go here. So let's just say it's $50,000 and you're assigning it to them for a $10,000 assignment fee. Basically, they're paying $60,000. And that's exactly what you're going to add on the next line. So you put your purchase price here, your assignment fee here, and that total amount should go here. Okay. Because it goes on to say adding the assignment fee of $10,000, let's just say the assignee's total purchase price is the total between the purchase price and the assignment fee. So if it's $50,010 for your pocket, then it'll be $60,000 added here. It goes on to say in 6, this assignment and or real estate purchase contract may not be further assigned by the assignee without the consent of the assignor. So it's basically saying they can't go out and try to co-wholesale this deal out unless you give them permission. They have to close on this deal. They're the ones that signing the agreement as the buyer, and they have to perform on this contract. They can't assign this assignment of contract. Okay. 7 goes on to say assignee accepts all terms and conditions of the contract for sale and purchase between assignor and seller in its entirety. Okay. So that's basically saying that they're going to accept this entire agreement. And in fact, I want to add something. It says the assignee shall pay assignor an assignment fee. I'm going to add the assignor a non-refundable assignment fee in the amount of non-refundable assignment fee. And I'm going to make that bold there, by the way. So now it says the assignee shall pay the assignor a non-refundable assignment fee in the amount of whatever the assignment fee is. Okay. And then I'm also going to copy this and I'm going to add a non-refundable earnest money deposit here. Okay. And the reason why I didn't have it there before is because this is a newer agreement that I've been using recently. But on my older contract that I used to use, it had this. So I'm basically combining it with this to make this more foolproof. So number 8 goes on to say this assignment is contingent on the seller providing clear and marketable title to assignee prior to the closing date. Now, even though up here it says non-refundable assignment fee and non-refundable earnest money deposit, if the seller cannot provide you as the buyer with a clear and marketable title, then technically you have to give back the earnest money deposit to your buyer because they can't purchase the property. So the only way that this assignment fee and this earnest money deposit is going to be non-refundable is if you can clear the title on the property. All right. And that's obviously, that's all up in the air for negotiation as well, because at the end of the day, you can negotiate. Let's say that there's liens on a property. You can negotiate with the seller to pay the liens off based off of how much equity is actually in the property, based off the breathing room that you have. And then you can pass that on to the buyer. If the buyer is willing to pay it, then the disclaimer in number 8 becomes irrelevant at that point. So basically keep in mind that it's all up in the air for negotiation, but on a normal deal, the title must be delivered free and clear of any liens and encumbrances and things like that in order for you to be able to sell the property. And that's how you're going to be able to make the money on the other end. It says in the event that clear and marketable title cannot be obtained, assignee shall be released from this assignment. One thing you want to keep in mind is if you negotiate that the buyer is going to pay any liens and they don't care that the house is not being delivered free and clear of any title issues, then you just want to simply delete this line out. All right. You can simply cross it out and have the buyer initial right next to it, and then you initial next to the buyer. Okay. Number 9 says assignee acknowledges receipt of legible copies of the original contract for sale and purchase, which basically means you're going to give the buyer a copy of the original purchase and sale agreement between you and the seller. You have to do that. Okay. Then it goes on and says, in its entirety, including all addendums associated with this agreement. Now, the reason why you want to give the assignee access to this, number one, is because they're actually purchasing the agreement from you. They're not purchasing the house from you. So you want to be careful not to say that you're selling a house. All you're doing is assigning your rights in the house over to the buyer. So you want to make sure that they have a copy of the original agreement, and you want to make sure that they have a copy of this assignment of agreement of sale as well. Number 10, assignee acknowledges that the property will be delivered without tenants in possession unless otherwise noted. If the buyer is purchasing the property from you with tenants in there, then obviously you would cross this line out. Again, make them initial it, and then you initial right next to them. All right. In the event that assignee fails to close this transaction or is in default of this agreement, the assignor shall have the right to terminate. Now, remember, you're the assignor. You would have the right to terminate this agreement of contract and declare the assignee in default, wherein assignor, again, you, shall A, retain the sum of deposit indicated on line 4 as liquidated damages. So that basically validates this non-refundable earnest money deposit right here. Okay. And then it says B, all right, title, and interest pursuant to real estate purchase contract shall automatically revert to assignor without notice. Basically stating that this assignment of contract is no longer valid. All right. Then your buyer will simply initial here, and you can initial there as well. Then it says disclosures and acknowledgments. Seller sells property as is with no warranty of property conditions, meaning the buyer is purchasing his property as is. Assignor, which is you, makes no representation to buyer or his agent as to the condition of the subject property. Again, they're purchasing it as is. Assignee acknowledges and agrees that he or she is purchasing the property on an as-is basis and based on his or her inspection, investigation, and evaluation thereof. Assignee is not relying on any representations of assignor, seller, or seller's agents to investigate and report on the condition of the property. So all this is saying here is that the assignee, which is your end buyer, knows that they're purchasing the property as is, but they will have time to inspect the property on their own. They have to do their own homework, have to do their own due diligence. And this basically tells them that they're not relying on any information from you in order to be able to do their own due diligence. Okay. Goes on to say B, examples of matters as to which seller disclaims all warranties, representations, or guarantees expressed, implied, or statutory, written, or oral are including but not limited to roof, plumbing, electrical, appliances, sewer, soil conditions, foundation, heating, air conditioning, structural, and pool related equipment if applicable. All right. So again, just looking at this first line here, examples of matters as to which seller disclaims all warranties, representations. Again, this is basically stating that the buyer will have to do their own due diligence. They're purchasing the property as is. The seller is not guaranteeing anything. Assignor, seller, and seller's agent do not warrant that the property meets any current city, county, state, or federal building codes. So again, they're purchasing this property as is. You're not stating that this property is up to code on anything. Your buyer is purchasing it as is. Then it goes on to say, as well as the presence of any and all outstanding or pending violations against the property. Assignee, which is your buyer again, assumes all responsibility to perform any inspection, investigation, and evaluation thereof prior to the signing of this agreement. D goes on to say, assignor and affiliated associates make no warranty expressed or implied, regarding inspection reports or other reports provided to assignee by assignor or third parties concerning this property. Assignee, which is your buyer, is advised to independently verify the accuracy of all information contained in the reports regarding this property. And finally, assignee acknowledges they are conducting a transaction dealing directly with the assignor, which is you, for the purchase of subject property. Assignee is not relying upon or being represented by assignor or any other real estate brokerage in this transaction. 13 says additional terms and conditions, if applicable. Assignee will pay sellers back property taxes as well. This is just an example that I added here, but this can be erased and you can leave it blank if necessary. Okay. Then you and the assignee will sign here. So you would sign as the assignor. Your buyer will sign as the assignee. And then you will collect an earnest money deposit, or they will deposit the earnest money with the title company or attorney that's closing a deal based off of the area that you live in. And then you will go ahead and get the process started in order to get the deal closed.
All right, so there you guys have it. That's the assignment of agreement of sale. Now, as I promised you, somewhere in this video, if you watch the entire video, you would have seen exactly where to get this document. So be sure to watch it if you missed it, and make sure you get access to this document in order to download it, in order to be able to use it in your real estate investing business as well. Be sure to like this video, subscribe to this channel, and leave a comment below with any questions in regards to the assignment of agreement of sale. Click the notification bell as well for future videos just like this one, and I'll talk to you guys on the next one.